She said it herself. Nobody put words in her mouth. Nobody led her into it. No trick question. No complicated legal framework. No classified document placed suddenly in front of her. Just a straightforward procedural question about how she does her job. And Pam Bondi answered it clearly, confidently, and without hesitation. Yes, standard protocol. All major transfers. 5 words. Under oath. On live television. In front of 289 witnesses. And in those 5 words, she handed Ted Lieu everything he needed to corner her, because 40 minutes later, when Lieu placed a single sheet of paper on the witness table, a wire transfer for $847,000 bearing what appeared to be her signature, she could not confirm it was hers. The Attorney General of the United States, the chief law enforcement officer of the country, the woman who had just testified under oath that she personally reviews all major transfers as standard protocol, could not confirm her own signature on an $847,000 transfer authorization form. Watch this video until the end, because what happened between those 2 moments, between yes, standard protocol, and 92 seconds of silence, is not a story about a document. It is a story about 2 sworn statements that cannot both be true, and only one of them can be a lie. To understand what made this morning different from every other Bondi hearing, you need to understand what September looked like. 3 months earlier, before the Senate Intelligence Committee, Bondi had been asked a direct question about DOJ financial activity during her tenure. The question was specific. Had she had any knowledge of settlement transfers connected to classified matter designations? Her answer was equally specific. I have no specific knowledge of settlement transfers in that amount connected to classified matter designations. That sentence was entered into the Senate record. It was preserved under penalty of perjury. It was specific enough to be legally meaningful and broad enough to sound like a complete denial. No knowledge, no specific awareness, nothing connected to classified designations. That was September. That was the wall she had built. And this morning, she walked into room 2141 of the Rayburn House office building, sat down at the witness table, and began dismantling that wall herself, one word at a time. Bondi's opening statement lasted 12 minutes. She used the word transparent 7 times. She cited coordination with career prosecutors. She mentioned interagency protocols. She projected the confidence of someone who has done dozens of these hearings and knows exactly how long her prepared paragraphs need to last before the clock runs out. Her attorneys nodded at intervals. Practiced, professional. The performance of an official who believes she has already survived the worst of it. What she did not know, what her attorneys did not know, was that Lieu had arrived 43 minutes before the scheduled start time, that he had reorganized his folders alone, that a plain manila envelope sat face down on his left side, waiting, and that the question he was about to ask was not about the document in that envelope. Not yet. The document was the second move. The first move was her. When Lieu's name was called, he did not open with the transfer. He did not open with the signature. He did not open with anything that would trigger a defensive posture from Bondi's legal team. He opened with procedure. Attorney General Bondi, in your role overseeing financial settlements processed through your office, did you personally review authorization forms for wire transfers exceeding $100,000? It was the kind of question that sounds like the beginning of a longer, complicated inquiry. The kind of question officials answer on autopilot, because answering it doesn't feel like a risk. Bondi answered it on autopilot. Yes, standard protocol, all major transfers. She did not hesitate. She did not qualify. She did not add in most circumstances, or subject to delegation, or any of the other phrases experienced officials use to preserve flexibility. She said yes. All major transfers. Standard protocol. And she said it under oath. That answer was not a mistake. It was a habit. The habit of a witness who has been so well prepared for the dangerous questions that she stopped paying attention to the harmless ones. And that habit, that single reflexive answer, made everything that followed inevitable. Here is what that sentence did. In one breath, Bondi established 3 things on the permanent record. First, she reviews all major transfers personally, not deputies, not delegated staff, her. Second, $847,000 is, by any definition, a major transfer. Third, if she reviews all major transfers, she reviewed this one. There was no longer any universe in which she could claim ignorance of the $847,000 wire transfer that left the Department of Justice on February 8th, 2 days into her tenure. and arrived at a shell company in the Cayman Islands with no employees, no physical address, and no business history. She had just testified that she would have reviewed it, that she personally handles authorization forms for transfers of this size, that it is standard protocol, her protocol. And she said it before she knew what Lieu was about to place in front of her. That is not a trap in the theatrical sense. There was no trick, no deception, no manufactured evidence. Lieu simply asked her how she does her job, and her answer made the document deadly. Lieu reached for the manila envelope. He removed the single sheet and slid it across the witness table without speaking. He let the paper travel. He let every camera find it. He let every attorney at the defense table read it before Bondi did. He let the room understand what was happening before he said a word. Then, I'm going to ask you to look at the document in front of you. Bondi looked down. The document was a wire transfer authorization form dated from her tenure. Amount, $847,000. Destination, an account flagged by Treasury analysts as a suspicious activity candidate before the transfer cleared. The flag had been reviewed internally, then it had been removed. The removal memo bore 3 words, "Matter is classified." And at the bottom of the form, on the authorization line, a signature. Lieu had not told her what the document was. He had not summarized it. He had not given her attorneys time to formulate an objection before her eyes had already reached the signature line. The lead attorney rose immediately. She requested a brief recess for her client to review the document with counsel. Lieu said no. The document was already in the congressional record. The witness had just testified she reviews all transfers of this magnitude. He had one question. Attorney General Bondi, is that your signature on the authorization line of this wire transfer settlement form? Yes or no? I need to stop here. If you have watched this far, hit the like button right now, because what you are about to understand is not just what happened in this room. It is why Bondi's own testimony from this morning made it impossible for her to answer. She said she reviews all major transfers. That means she reviewed this one. If she reviewed it, she knows whether she signed it. The question should have taken 1 second to answer. It took 92 seconds and a Fifth Amendment invocation. Why? Drop your answer in the comments. Because the reason matters more than most people realize. The reason the question was unanswerable is not complicated. It comes down to arithmetic. Simple, brutal arithmetic. 2 statements, both under oath, both in official federal proceedings. Statement 1. September, Senate Intelligence Committee. I have no specific knowledge of settlement transfers in that amount connected to classified matter designations. Statement 2. This morning, House Judiciary Committee. Yes, standard protocol, all major transfers. Now add the document. A wire transfer authorization form for $847,000, connected, through the matter is classified removal memo, to a classified matter designation, bearing what appears to be Bondi's signature. If Statement 2 is true, if she reviews all major transfers, she reviewed this one. If she reviewed this one, she had specific knowledge of it. If she had specific knowledge of it and it was connected to a classified matter designation, Statement 1 was false. Under oath, in a federal proceeding, that is perjury. 3 elements. Statement made under oath. Statement that is false. False statement that is material and made with intent to deceive. All 3 present. And the document, her document, produced by her office, authenticated by 2 independent forensic analysts, was the proof. So, when Lieu asked her to confirm the signature, he was not asking her to confirm a fact. He was asking her to complete a perjury analysis on the record. A yes confirmed the transfer. A yes confirmed her knowledge. A yes made Statement 1 demonstrably false. A no was worse. A no claimed the signature was fabricated. It accused a federally regulated financial institution of submitting a fraudulent document under penalty of perjury. It opened her to immediate forensic contradiction by the analysts who had already authenticated it. There was no answer available that did not destroy her on the permanent record. And her attorneys had understood that from the moment the document left the manila envelope. Watch what happened in the 40 seconds between Lieu placing the document and Bondi's lead attorney rising to request a recess. Bondi looked at the page. Her lead attorney leaned left and whispered something. Bondi's chin did not move. Her eyes stayed on the document. Then the attorney stopped picking up her pen. That was the signal. In the language of legal teams in high-stakes proceedings, a lead attorney who stops taking notes has made a calculation. The calculation is this. There is nothing to note, because the situation has moved beyond notes, beyond strategy, beyond preparation, into territory where the only decision left is which invocation causes the least damage. The recess request was not a delaying tactic. It was a signal to the committee that the legal team had already identified the problem and was moving toward the only available response. When Lieu denied the recess, he accelerated that process. He removed the buffer. He forced the decision into the open. And 92 seconds later, that decision was announced. Pursuant to my client's constitutional rights and the procedural protections afforded under the Fifth Amendment to the United States Constitution, my client respectfully declines to answer that question at this time. The Fifth Amendment exists for good reason. It is a foundational protection. Invoking it carries no legal presumption of guilt. But context matters, and the context here was specific and unavoidable. Bondi had not been asked about classified information. She had not been asked about national security. She had not been asked about executive deliberations, or attorney-client communications, or any of the categories where an invocation might look like principled caution rather than legal necessity. She had been asked whether a signature was hers. That is the most personal fact a witness can be asked to confirm. Either the signature is yours, or it is not. There is no classification concern, no privilege, no deliberative process to protect, no national security implication, just a name on a line. And Bondi invoked the fifth rather than say yes or no. The public does not hear constitutional protection in that invocation. The public hears, answering this question would incriminate me. And if confirming your own signature incriminates you, there are only two explanations. Either the signature is yours, in which case confirming it proves your September testimony was false, or the signature is not yours, in which case you cannot explain why a federally authenticated document bearing your apparent name exists in the congressional record. Both explanations are incriminating. She invoked the fifth because there was no other move, and in making that move, she answered the question more clearly than any yes or no could have. What the cameras in the gallery did not show was the second envelope. Throughout the entire hearing, Lieu held a sealed exhibit in reserve. He never opened it. Its contents were not read into the open record, but it was submitted under seal as Exhibit C in the Inspector General referral he filed within 24 hours. An FD 302, an official FBI witness interview report, documenting the account of a career Department of Justice attorney who had been present during internal discussions about this transfer. The attorney described what happened when Treasury analysts flagged the $847,000 transaction as a suspicious activity candidate. A flag was raised. A suspicious activity report was prepared. Then something unusual happened. The flag was reviewed by someone at leadership level, and it was removed. The removal was justified internally by invoking a classified matter designation. But according to the career attorney's account, no formal classification review had been conducted on the transfer itself. The classification designation had not been applied through proper channels. It had been invoked by someone with authority to invoke it, to suppress the suspicious activity flag before the SAR could be filed. When the career attorney raised concerns about the appropriateness of using a classification designation this way, those concerns were dismissed. The matter, they were told, was not subject to further internal review. That FD 302 is now in the permanent congressional record. Its chain of custody is unbroken, and it documents a pattern that the wire transfer document alone could only suggest. Someone at leadership level used classification authority to bury a Treasury flag on a transfer that was flagged as suspicious. The authorization form for that transfer bears Bondi's apparent signature, and when asked to confirm the signature, she invoked the fifth. The IG referral Lieu submitted within 24 hours contained 3 exhibits and 1 central question. Exhibit A, the wire transfer authorization form. Exhibit B, the matter is classified flag removal memo. Exhibit C, the sealed FD 302. And the central question, Did the evidence support criminal referrals for perjury, obstruction of justice, or abuse of classification authority? That investigation is now active, and it begins with 2 sentences. I have no specific knowledge of settlement transfers in that amount connected to classified matter designations. Spoken in September, under oath. And, yes, standard protocol, all major transfers. Spoken this morning, under oath. 2 sentences, 2 proceedings, 2 sworn statements, 1 document that makes them mutually exclusive, and 1 attorney general who, when asked to confirm whether the document bore her signature, chose the Fifth Amendment over a yes or a no. That choice is now in the permanent congressional record, alongside the document, alongside both testimonies, alongside the flag removal memo, alongside the FD 302. All of it documented, all of it authenticated, all of it permanent. Pam Bondi walked into that hearing this morning with prepared paragraphs and a legal team and 12 minutes of opening statement. She walked out with a Fifth Amendment invocation on her record and an Inspector General investigation active on her signature. Not because Lieu caught her with a document she didn't expect, but because he asked her 1 procedural question she answered without thinking. And the answer she gave made the document impossible to survive. She testified she reviews all transfers. Then she couldn't confirm her own signature on one. That contradiction is the record. And the record does not forget.